Hey, welcome to another edition of Fight for Justice. Those of you who've never seen this show before, we try to bring you topics of interest on legal subjects, some of which you may know something about or you may not know anything about. You're always welcome to email us and send us topics you'd like to see us cover. Tonight, we're going to go over the general subject of torts, that is wrongdoing by somebody which results in an injury. When we get to the last segment of the show, we're going to do something a little bit different. The TV 24 staff has from time to time gone out in the neighborhoods or at some event, and they've captured questions from people who had a legal question they'd like to have answered. We're going to play some of those back, and we're going to try to answer them. Some of them involve criminal subjects, and we don't do criminal work, but we're going to hit on them anyway, and I think you'll find them interesting. The first topic tonight, and if you'll put up on number one on the screen, we get a lot of questions about some of the subjects we're going to cover tonight. The first one concerns injuries caused by animals. Freeman, talk a little bit about injuries caused by animals.
Oh, in general, there's a couple things that you really need to think about, and we're not going to cover any of these in great detail just because we don't have time. We'd have to do multiple shows on these. But generally speaking, when you're dealing with injuries by an animal, the owner or the keeper of that animal has to have some prior knowledge of that animal being dangerous or, maybe biting at somebody, attempting to bite somebody. And then the other general thing that you need to know is that if you're in an area or a municipality or a county where there are leash laws, if an owner or a keeper of an animal is off their property and they do not have the dog or other animal restrained by a leash, and then they attack you or bite you or what have you, then you may have a negligence per se theory available to you, which basically means that's negligent on its face. That's it, generally speaking, with injuries by animals. I don't know if you have anything you'd like to add.
Yeah, I do. There's another category that you have to be aware of. We've all been concerned from time to time about the pit bulls. There's a big feeling that pit bulls are naturally dangerous. Well, there is another way that you can go after somebody, and that's if you own a dog that has a natural propensity to commit violence or bite folks or things like that. You can sue that person if they let that dog that has a natural propensity for violence or dangerous. You can sue them just on that, whether they have ever done it before or not. And the owner has to know that. You have to be able to prove that. So let's just say that the general perception that a pit bull is dangerous. That's not always true, by the way. I've known people with pit bulls who are very great pets, but the perception is they're not. So if somebody has a particular dog that's, let's say one of these dogs that comes back from the war somewhere and is bred for attack, those people that owns a dog like that and doesn't keep them leashed up and they attack, you can sue them and win, more than likely anyway. One other thing that you have to have, though, in any lawsuit, whether it involves dogs or not, is that you have to suffer some substantial damage. Just because it made you angry or mad, or maybe it brushed against your leg and didn't do anything, lawsuits don't belong there because there's no damages. So you have to have liability and you have to have damages, and they have to be substantial to justify making a claim, or if the claim turns into a lawsuit, you got to have that. So what Freeman was talking about with dogs, once you know that dog has done that, every dog that's normally docile is given, and we say in Alabama, one free bite. So if the dog has never bitten before and does, that owner better keep him leashed up, or he could be responsible for any damages caused.
It's not just keeping them leashed up, because you could be on someone's property, and that's where that what he's talking about, the one free bite, really comes into effect is if you go visit someone's property and you're a guest of that person and they don't have that dog restrained in some way, fenced or, in a separate room, and they know that dog has bitten someone before, then their carelessness or their negligence in keeping that dog can then come into play if something should happen.
Yeah, and you've got to, if you're the plaintiff who's been hurt, you've got to be able to prove that dog has a known propensity for violence or dangerousness or has had bites before. You got to be able to prove it. It may have happened before and you don't know about it. So that's what you have to do with those kind of dog bite cases. I remember once when I was taking a school trying to learn how to ride a motorcycle. I went to Montevallo, and one of the things they taught us was, what do you do when a dog starts chasing your motorcycle? And this is a little bit off the subject, but if that dog is known to chase motorcycles, maybe the owner might be responsible for that. What they tell you in motorcycle school is you should slow your bike down to a complete stop, wait till the dog stops, and then fire it up, and you'll outrun that dog every time. I only tried that one time, but it worked. But that's the kind of things you have to know about if you're going to hold an owner responsible for liability. And if you're the owner, you need to take precautions to make sure that somebody in the public is not injured. So, and this gets into also a question of negligence by the owner. Freeman, you want to comment generally on negligence?
Yeah, I think we got the slide. We're going to talk about it, and we've talked about this before with other things, but negligence in general, you have to have a duty, a breach of that duty, and the breach of that duty has to cause an injury, and lastly, of course, there has to be an actual injury. But negligence in general is just a failure to exercise reasonable or ordinary care such that a reasonable, prudent person would have exercised under similar circumstances. And then I think also on that slide we had contributory negligence and assumption of the risk. I'm not sure if we have time before the break to really get into that, but contributory negligence we've talked about before is if you're, for instance, if you're hit by a car but you're speeding, then you can be deemed if you're negligent also in that situation.
All right, we'll come back to that in a second and explain a little that more in detail. We're also going to talk about general premises liability. So stay tuned. We'll be back after this brief break. Okay, before the break, we were talking about negligence generally, and the defenses to negligence are contributory negligence or assumption of risk. Those are a couple of them, and Freeman was about to explain those to you. You can have a claim against somebody for negligence, but you may be barred from winning that claim because they have a defense against you that you were contributory negligent or that you assumed the risk. Pick up where you left off, Freeman, on contributory.
Just quickly, we were talking about contributory negligence, and that's basically, if you're hit by a car, but you're distracted because you're texting your phone or looking at your phone, you may have been able to avoid the accident, or you could be deemed to have been able to avoid the accident if you hadn't been looking at your phone. And so your negligence may have contributed to that, and that can bar you from recovery. And
that explains why there's so much publicity now about people shouldn't be texting or using their phone while driving an automobile, because that can make you negligent and you can be barred.
I believe that we even had, we weren't involved in it, but I believe that we even had a case here in Calhoun County sometime in the last couple of years where a person was just north of Jacksonville and was turning across Highway 21 and somebody was speeding, but he or she was looking at his or her phone and was deemed to have contributed to the accident by doing so, even though you could look at it and say, probably wouldn't have mattered, but
Well, that's an interesting idea, because you could also be negligent yourself by using that text or paying attention to your telephone, and you could have caused an accident that the other driver couldn't have prevented. For example, you might run a stop sign. How many of you have ever run a stop sign and just didn't notice it? And why didn't you notice it? You sit there playing with your phone, and there's a stop sign and you don't see it. And there was a segment on 60 Minutes this week on television about people who don't pay attention to school bus signs, and they put the stop sign out. They go right around them, and they showed some little kid getting hit by a car. That's negligence, obviously.
I think you could make the argument that that'll go on to what we'll talk about after we talk about the next defense that we're going to talk about, assumption of the risk. That could be wanton and willful. And
that would subject you not just to ordinary damages, but punitive damages, which is designed to punish you. And that can be substantial. Let's go on and talk about assumption of risk.
Assumption of the risk is basically you've given your consent, whether it's express or implied, to a known danger arising from the person you're trying to sue for their reckless or negligent conduct. And there's a lot of different scenarios. My favorite is that I like to tell people is that, if you're riding by a golf course, there's a chance that a ball could come, somebody might hit a bad shot, and it may hit your car. And the question is have you assumed the risk by taking that road that goes right by that golf course, knowing that that's a possibility?
Let me give you a more common example that occurs every weekend. Playing football. If you're going to play football, you have assumed certain risks. And some of those risks are that the sport is a contact sport. You can get injured, and you've assumed that risk. And when that happens, the other guy's not liable, except in the case where it's intentional. And you have these chop blocks and that sort of thing that are illegal. And that moves it across the line from assuming the risk to probably holding you responsible or the other guy responsible. You agree with that?
Yeah, I don't think that you could, reckless or negligent might not necessarily mean wanton or willful. So, and we'll talk about the difference in those. But that basically, you're talking about an intent to harm, and I don't know if you could foresee that and be deemed to have assumed the risk of that happening.
I know I used to play racquetball, and if any of you have ever played racquetball, you will find out that it can be very dangerous because somebody can let go of a racket and that ball can come right back and hit you in the eye. You're supposed to wear protective gear. What if you're not doing that? You may have assumed the risk of that injury by not protecting yourself. But otherwise, and you can assume the risk is you'll get hit by a racket. I've been hit by a racket many times, and I always try to look over my shoulder to make sure that guy behind me is not too close to me. But that's one of the risks of playing racquetball, unlike tennis, which is not so bad. Well, anyway, let's go on to the next subject. If you would put that graphic back up. Now we're going to talk a little bit about premises liability. And Frim, would you explain what we mean by premises liability?
Basically, that's going to be situations where we're dealing with you as a guest of somebody else, whether the legal terms are whether you're an invitee, you're a licensee, and basically that's going to mean an invitee is basically if you're at someone's place of business. If they are going to invite you into their store and they're going to get something out of it, like you possibly buying something, then they're going to owe you a higher standard of care. And they've got to take care of that property more so than they would if you're a licensee or even a trespasser, which in case they really don't owe you anything.
Yeah, let's talk a minute about what is a trespasser.
That's an uninvited guest.
Somebody is not welcome on your store
right.
or your home. They're a trespasser. Do you owe them a duty to keep your premises reasonably safe?
Well, you don't owe them anything. They can't, unless you intentionally harm them or you're reckless in some way, then you don't owe them the care that you do.
But just
simple
negligence, like leaving something on the floor they trip over. They can't sue you for that. But a business invitee or a guest in your house can do that just by leaving something to obstruct their pathway. That's kind of the difference. So a trespasser just takes everything as he finds it, and he's not going to be able to hold you responsible if he's on your property and gets injured ordinarily. That doesn't mean, however, that you can't set a trap. We've all seen movies where people dig holes and put a net over.
You cannot do that.
You can't do that.
Let's make that clear. You cannot
them.
booby trap your property or your house to catch somebody. The other thing that's important to note is that a licensee is essentially a guest in your home. there's no commercial aspect of that relationship. They're not getting anything out of it. And it's also important to know that if you're an invitee, you can lose that status. As soon as, if they ask you to leave their store,
That's right.
then that relationship is over. And I've seen case law also where someone goes to pick another person up from a store, and because there's no business relationship there, they also don't have that status as well.
So what we're really saying is the degree of liability that the landlord or the owner of the property has for you depends on what your status is, how you got there. Or did you get invited? Did you bust through a window and come in as a trespasser? Makes a huge difference. But you've got to use ordinary care for people who are invited or who are guests on your property not to injure them. Ordinary care means don't have any hidden defects or warn them about them if they're there. That's the essential difference.
Yeah, I think there's also an open and obvious aspect to that as well. And I think
talk about that for a minute.
We've had cases, actually we had one on a golf course.
Yeah.
Where someone fell into a hole. Mm-hmm. And the argument was that, well, these people, the grounds crew, they're out there every day. They should have known this enormous hole was there and it was covered in grass. So if you weren't familiar with that place, then you wouldn't know about it. You're an invitee in that situation because you're paying for the use of that golf course.
Well, you mentioned open and obvious. An example of that, I had a case. This involves some kind of a step. You got something you got to step over that's painted yellow. It's open and obvious, and if you don't see it, you're not going to be able to hold the owner liable. So that's the defense. All right, we'll come back in a few seconds with our third segment. We'll have some questions by people from on the street, and I think you'll find it fun. See you in a minute. Welcome back to the third and final segment tonight. We're going to take on where we left off, and then toward the end of this segment, we're going to play some questions from Man in the Streets. So we were talking before about landlord's liability.
Well, this is a little different than the premises liability, and here we're basically talking about whether a landlord knows of what's called latent defects, or where the landlord is voluntarily doing repairs, or where they're required to do repairs, and whether or not they've retained control over the property in some way or portions of the property in some way. Then they can be liable to the tenant for any injuries that they may occur. If a tenant is injured while the landlord is doing work to the property, then you can be deemed to be held liable for those injuries.
Yeah, and what we mean by a latent defect is something that you ordinarily can't see, but the landlord knows about and knows it might injure you. If he knows about those kind of defects, he's got a duty to warn you and a duty to fix it. Going on from landlords, what do you find to be the exceptions to that?
You want to keep talking about it?
Yeah, if you like.
The exceptions to landlords?
Mm-hmm.
You mean the exceptions to their duty?
Yeah.
I'm not sure what you have in mind there.
Okay. Well,
I think you've gotten mistaken with a different part of the slide. I think up next we're going to talk about slide 3, which we're going to talk about the guest statute and bad faith. The guest statute is something I think a lot of people find interesting, and basically what that says is if you're riding in someone else's car as their guest, the guest statute insulates the driver or the owner of the vehicle who injures or kills their passenger if they're acting negligently. Now, that doesn't cover that driver or that owner if there is wanton or willful behavior, which basically means that there is more of an intent to injure, that's willful, or if there's wanton, which is an omission of something, which there's a definite act there, like driving drunk or something like that, then the gas statute is not in play. But just everyday negligence, that is in play, and you can't recover against a driver if you're a guest or an owner. If the driver doesn't own the car, you can't recover against the owner either if you're a guest in a typical negligence situation.
By the way, let me go back to what we started out talking about. The landlord's liability is for latent defects. An exception would be where the tenant discovers a defect and knows about it, then it's no longer the owner's responsibility because he knows about it and he should take action to protect himself. That's what I meant by exception. And going back to the guest statute, Alabama is the only state in the United States that has this particular form of a guest statute, where the only type of damages that a guest passenger can recover is punitive. You can't recover compensatory. You can't recover your hospital bills, lost time at work, and things like that. Only punitive. It's kind of a ridiculous situation, but that's what it is. And as I think you mentioned this, that once if you are a consenting guest, then you take more of the risk on. But once you tell the driver of that car, slow down and let me out, and he doesn't do that, then he really has run the risk of some serious damages or injuries or money damage that can be awarded against him. If you'll put the slide back up, I think we're time to go to the next subject.
Real quickly, negligent entrustment basically involves a situation where that someone doesn't have the experience, or they're reckless, or they have a history of very poor driving skills in the instance of a car, and you let them take your car anyway. And if they go and injure somebody, then you're negligent in giving them that car or letting them drive that car because you know that they're not a good driver. Uninsured coverage we've talked about a lot before. That basically means that that's coverage that you buy in case somebody hits you that doesn't have insurance, or if they don't have enough insurance to cover injuries that you might have, and we always recommend everybody get that. Lastly, before we get to the video questions, is bad faith. This is where a situation like uninsured coverage where you actually sue your own insurance company. And basically, this is going to be a situation where the insurance company is just not paying a claim that they have no reason not to. They know they should be paying it, and they don't have a good reason not to, but they're just choosing not to do so.
All right, thank you, friend. We're going to get to the first video, man in the street interview, and somebody you may recognize. Are you ready to run the first question? Okay.
Hi, I'm Mickey Shadricks with TV24. We're excited about having Fight for Justice on our station every week. And my legal question today is this: what is the most interesting case that you've ever tried in the courtroom, and why?
All right, Freeman, you want to take this one because I know you got one to talk about.
I think the most interesting case that I've tried or helped try was a construction case that we tried last November. Took about a week and a half, and I think the reason that I enjoyed it the most is simply because I think there were 8 or 9 experts, generally in the same field, testifying about the same things, and the intricacies of how they interacted with each other and how you balance the testimony of that many experts. I think there were 4 on each side or something like that.
Yeah, I think we had a total of 28 witnesses.
Yeah, that was very interesting. Interesting one to do, and the fact that we won obviously made it a lot better.
Yeah, and we wouldn't. I thank you for Mickey about asking us about a case we won. We certainly wouldn't want to talk about one we didn't win, but it was a long, difficult trial, a lot of witnesses, and a lot of strategy involved in a case with that number of witnesses. When to present who and what to talk about and how to counteract their experts and what they were saying and how we respond to that. It was a lot of fun. Are you ready with the second man in the street question?
Hey Arthur, it's Carl Brady. I'm loving the show, but I do have a question. I have some friends who have a child in elementary school who's being bullied quite a bit. The parents have gone to the school, they've gone to the school board, and they've gotten no relief at all from what they feel the problem is. So they've talked to a couple of lawyers already who have said, not a chance in the world I'm going up against a school or a school board. What is your suggestion and your advice of what they can do to get some relief from this situation?
Well, that's a common topic of conversation is bullying, especially in the school setting. The school teachers and employees are standing in the place of the parents in a situation like that. And I think that we're having a developing situation there where the school boards can be responsible and liable for allowing that to continue once they know about it. So the first thing to do is complain to them. I would put that in writing. I would tell them when, where, and what the circumstances were. I'd ask them to take action to protect your child. And they don't do that, then if it came to me, I would be suing the school board for not honoring the duty they have to protect the children under their care and custody while they're there. Now, there haven't been a whole lot of those cases have been brought. When I was in school, in the early 60s or 50s, you just dealt with it yourself. You didn't complain to anybody, but that has really changed in the last 5 or 10
The
years.
other issue that you'll have there is whether or not you can actually sue a school board, whether or not they're immune from lawsuits.
Well, the school boards may be, but the individual teachers are not. And that's the distinction in Alabama law. That's one of the things we've run into is the school boards are immune. They're agencies of the state, but individuals are not. So that's it. We'll have some more of these in our next show. Questions from the public. I hope you enjoy that. And we'll see you next week, I hope. And in the meantime, be sure.
And remember, if you have questions or you have a topic that you want us to cover, you can email us at questions@fitelawfirm.com.
So do it.
See you next
answer.
week.